All right. So am I good to begin?
You are good to go.
All right. So my name is Kelsey Madden. I'm going to be your presiding judge today. First things first, are both sides ready to proceed to trial?
Yes, Your Honor. Greece is ready to proceed.
The prosecution is ready to proceed as well, Your Honor.
All right. To make sure that I've got the correct information here, I've got Bolivia for the prosecution and Greece for the defense.
Yes, that's correct.
Correct, Your Honor.
Fantastic. All right. So we do have the script to go through. If you've been doing this a while, I'm sure you've heard it many times. It doesn't all apply here, so I'm going to try and go through this in the most sensical way possible. I believe we do have your trial rosters. I see them here in our chat. I don't think we have any video recorders, but this is obviously being streamed. In terms of the Bar Association taking photographs, again, we've talked about this being streamed, and by competing in this competition, you have agreed to do so. All right. I don't think we have anyone in the gallery here. I believe we have just team members. And we've gone through our conflict check, and our scoring panelists have confirmed there are no conflicts. All right. So for teams and coaches, if there are any disputes arising out of this competition, they must be reported in accordance with the competition rules. Teams, your compliance. Oh, where did I go? Your compliance with time requirements will be considered in scoring individual performances. All right. Starting with the prosecution, would you like to introduce your team members?
Yes, Your Honor. On behalf of Team Bolivia, the prosecution, good morning, Your Honor, ladies and gentlemen, opposing counsel. My name is Kitty Wright, and I will be conducting the direct examination of Detective Jordan Markowitz, as well as the cross-examination of Avery Becker. Permission for my co-counsel to introduce themselves, Your Honor.
Yes, please.
Good morning, Your Honor, ladies and gentlemen of the jury, opposing counsel. I am Winter King, and I will be conducting the direct examination of Kyle Kuzak, the cross-examination of Blake Van Owen, and conducting the closing statement.
Good morning, Your Honor, ladies and gentlemen of the jury, opposing counsel. I am Anna Bensley, and I will be conducting the opening statement for the prosecution, the direct examination of Alex Cifuentes, and the cross-examination of Taylor Perkins.
Your Honor, at this time, may our witnesses introduce themselves?
Yes, please.
Good morning, Your Honor. My name is Victoria Johnston, and today I will be training Kyle Kuzak.
Good morning, Your Honor. My name is Kenzie Firkus, and today I will be portraying Alex Cifuentes.
Good morning, Your Honor. My name is Ben Harriman, and today I will be portraying Jordan Markowitz.
Right. Defense, would you like to introduce your team members?
Yes, Your Honor. My name is Good morning, excuse me, Your Honor, opposing counsel, and ladies and gentlemen of the jury. My name is Abby Miller, and I will be conducting both the direct examination of Taylor Perkins, the cross-examination of Detective Jordan Markowitz, as well as the closing statement.
Good morning, Your Honor, opposing counsel, and ladies and gentlemen of the jury. My name is Rachel Yett, and today I'll be doing the opening statement on the behalf of the defense. I'll be conducting the direct examination of Professor Blake Van Owen and doing the cross-examination of Kyle Kuzak.
Good morning, Your Honor, opposing counsel, and ladies and gentlemen of the jury. My name is Laura Thompson, and today I'll be performing the direct examination of Avery Becker and the cross-examination of Alex Cifuentes, as well as the preliminary matters. May our witnesses please introduce themselves?
Yes, please.
Good morning, Your Honor, and ladies and gentlemen of the jury. My name is Riham Abdunabi, and today I will be playing the role of Taylor Perkins.
Good morning, Your Honor, and ladies and gentlemen of the jury. My name is Chase Elkins, and today I will be playing the role of Elkins.
Good morning, Your Honor, ladies and gentlemen of the jury. My name is Emma Klausner, and today I will play the role of Avery Becker.
Right. Thank you all very much. All right. So at this time, we're going to swear in everyone. All right. Usually I'd ask you to stand for this, but stand or sit as you prefer for this. In an effort to maintain a level of professionalism and to uphold the code of ethical conduct during and after these mock trial proceedings, all members of the gallery, scoring panels, and teams shall stand or sit for swearing in to the oath of code of ethical conduct. First, team members, please raise your right hand. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Witnesses, do you promise that the testimony you are about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
Yes, Your
Yes,
Honor.
Your Honor.
I believe in here all we have are team members and jurors, so I'm going to skip gallery members. Scoring panelists, please raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and as objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
Yes.
Yes, Your Honor.
Right. Okay, a couple of things before we begin, just so we're all on the same page here. When I'm looking over here to the left, it's just I have a second screen next to me. I'm not doing something else. I just have my notes and the case problem up there. I apologize if my dog barks. We're obviously at home and I'm going to do my best to keep her quiet, but if you do hear barking, I apologize. And lastly, if we do have any technical issues, let me know that right away. If anything comes up, we'll stop and figure out how to deal with it in the moment. And lastly, if there are any health or medical emergencies that need to be addressed and we need to stop, alert me to that right away as well. With that, do we have any preliminary matters from the people before we begin?
Yes, Your Honor. Your Honor, the prosecution requests permission to reserve time on closing for rebuttal.
That will be granted.
Your Honor, in the rules for 5.4.7, it explains that rebuttals must be, the time for rebuttals must be reserved at the time of closings rather than preliminary matters.
I can let you know now. I'm going to allow that to be reserved, but we can address that at the time of closing then.
Thank you, Your Honor.
Your Honor, the prosecution also requests that in the event of any technical difficulties, the time be stopped until the technical difficulties can be fixed.
Certainly granted.
And finally, the prosecution requests that exhibits be constructively published to the jury only after their admission.
Yes, so I think what we'll do is you can feel free to share it on the screen, to show the witness, to show me. We'll just constructively assume the jury is not seeing it until such time that it is admitted.
And Your Honor, we ask that the last two preliminary matters be granted to the defense as well.
This will apply to both sides, yes.
Thank you, Your Honor. No further preliminary matters.
Preliminary matters for the defense?
Yes, Your Honor, we just wanted to let you know, as we're competing from the same school, we might need time from the exchange of the witnesses to sanitize and clean the areas, so there might be a slight delay.
Certainly, and I did see in the chat that you guys are there, so just let me know whenever something comes up or if you need more time. I'm happy to give you that time to do that.
Thank you. And we also wanted to know if in this court, recrosses and redirects will be allowed.
Certainly redirects, typically not recross them.
Thank you. No further preliminary matters.
All right. And with that, for the people, are you ready to proceed with your opening statement?
Yes, Your Honor, may I begin?
Begin when you're ready.
Our actions prove the truth of our words. We are here to prove the defendant guilty of the actions of first-degree murder, Mackenzie Brackman, and second-degree burglary of a dwelling. The defendant says they are innocent of these crimes, yet you will find their words in accordance with their actions will be proof enough. Our story begins with Mr. Mackenzie Brackman. Mr. Brackman was a hardworking lawyer with a passion for training an upcoming generation of lawyers because Mr. Brackman was a high school mock trial coach. Mr. Brackman devoted lots of his precious time to setting the members of mock trial up for success at their competitions. Now, let's proceed to the reason we are here. On March 6, 2020, Mr. Brackman was murdered. Mr. Brackman was starting his long weekend when he was surprised by an intruder breaking into his home. The intruder entered the home, likely unaware that Mr. Brackman was not at work that day, found him at home, engaged in physical combat, and then used a kitchen knife to murder Mr. Brackman. You may now be asking yourself why, and you must be asking who would lash out against Mr. Brackman in such a way. The prosecution also had these questions. First, it is important that you understand the actions taken by the defendant leading up to the day of the murder. As the defendant chose to ignore guidance provided by Mr. Brackman and instead relying on natural talent when preparing for mock trial competitions, disagreements between the defendant and Mr. Brackman were common. Mr. Brackman started out by punishing the defendant and removing the defendant from the A team before the important regional tournament, which the defendant was able to return to when their best friend, Taylor Perkins, a fellow senior, immediately removed themselves from the A team as well. Then, sometime after the regional tournament, the defendant took their disagreements personally and vandalized Mr. Brackman's car, writing "Worst Attorney Award" in permanent marker. Mr. Brackman then removed the defendant from the team completely, which angered the defendant and caused them to lash out against Mr. Brackman. Today, the prosecution stands before the jury with the burden of proof. It is our duty to prove beyond a reasonable doubt the existence of all the elements necessary to convict the defendant of first-degree murder and second-degree burglary. These will be proven beyond a reasonable doubt through the witness testimonies and exhibits you will see today, especially the testimony of the prosecution's 3 witnesses. Beginning with an expert witness, Kyle Kuzak. Kuzak has 19 years of experience as a certified crime scene reconstruction investigator. Ms. Kuzak visited the scene after it was processed by other members of the crime lab and also reviewed the home security video footage and photographs taken of the crime scene. Ms. Kuzak will describe her investigation methods that led to her concluding there had been a physical struggle and that the intruder indeed was the murderer of Mr. Brackman. You will then hear the testimony of Alex Cifuentes, a fellow mock trial member of the defendants. Alex will recount to the jury how she exchanged text messages with the defendant prior to the murder of Mr. Brackman, where the defendant's words clearly express their intent to break into Mr. Brackman's home and are backed up with their actions when they did just that and more. The third witness will be Detective Markowitz. Detective Markowitz has been a homicide detective for the Denver Police Department for 7 years and has a certification in cell phone technology. Detective Markowitz's investigation included reviewing the video footage taken of the intruder, who he will describe as matching the height and build of the defendant, as well as using his training in cell phones to show the whereabouts of the defendant's phone the day of the crime. In addition, based on pieces of indirect evidence, Detective Markowitz will show you how he came to his own conclusion that the defendant killed Mr. Brackman. The defense may try to paint the defendant as apologetic and willing to make amends with Mr. Brackman. However, this is not the case, and when the prosecution puts the pieces together of this story, it will become apparent that the defendant's words and actions were their undoing, as they eventually brought them here, where they are charged with 2 serious crimes, 2 crimes that we will prove beyond a reasonable doubt. Although the defendant may verbally deny the accusations, you will see that the prosecution will show that their actions prove their words.
Thank you. Opening statement for the defense?
Yes, Your Honor, thank you. The less I see, the more I know. Ladies and gentlemen, you're here today because of the loss of Mr. Mackenzie Brackman, a local defense attorney and the Colorado High School mock trial coach. In March of last year, Mr. Brackman's mock trial team had just won the regional competition and was preparing to go to state when Mr. Brackman was murdered inside of his own home. Now you're here today because the prosecution believes Avery Becker, a good worker, a smart student, a committed mock trial participant, a daughter, a friend, a good person. You're here because the prosecution believes Avery Becker did this. You'll hear from Avery Becker herself today, and she will tell you that although her and Mr. Brackman had their small and petty disagreements and arguments surrounding mock trial, she could never hurt him. Ladies and gentlemen, Avery Becker has no duty to testify here for you today. She has nothing to prove to you, and she's simply here to clear her name. The less I see, the more I know Avery Becker is being wrongly charged and tried of this crime. The defense will also call Taylor Perkins to the stand. Taylor Perkins is Avery Becker's best friend, and Taylor will verify she was with Avery Becker almost the entire day of March 6th, and there's no possible way Avery Becker could have committed this crime. The less I see, the more I know Avery has a simple alibi. Today, the defense will also call Professor Blake Van Owen to the stand. Professor Van Owen is a private investigator who's the best at what he does. And Professor Van Owen will show us the multiple holes in the prosecution's case and show us that there is reasonable doubt here today. You'll also hear from 3 prosecution witnesses. Kyle Kuzak, a crime scene reconstruction investigator with the same training as our very own Professor Blake Van Owen. Kyle Kuzak will not present you with any hard evidence linking Avery Becker to this crime scene. The less I see, the more I know she simply wasn't there. Today, you'll hear from Detective Jordan Markowitz, the head detective of this case. Detective Markowitz will tell you that they obtained videos of the intruder entering the home of Mr. Brackman, but the less I see of Avery Becker on these videos, the more I know she wasn't there. You'll hear how the police force lost crucial evidence to this case. The less evidence I see, the more I know the police did not utilize all of their resources and materials that they could have to conduct a thorough investigation of this case. You'll hear how only one suspect was thoroughly investigated by the police and the prosecution. The less suspects I see, the more I know. Lastly, you'll hear from Alex Cifuentes, a high school student much like Avery Becker. Alex was on the mock trial team with Avery, and ladies and gentlemen, as you hear their testimony today, I ask you to look for any bias that you might see. The less I see, the more I know Alex will not present you with the accurate details of this case today. Now today, the prosecution has the burden of proof. They must prove to you beyond a reasonable doubt Avery Becker is guilty. Today, you will see the prosecution fail to meet that burden of proof. The less I see, the more I know the prosecution's witnesses will fail to show you Avery Becker is guilty. Now, ladies and gentlemen, as we go into this case, I ask you to ask yourselves some questions. Should I be seeing more from the prosecution? Is this all there is I need to see? Is this all there is I need to know? Do I know for a fact Avery Becker is guilty? Now, the defense doesn't have a burden of proof, but we will show you the prosecution wants you to see less and feel like you then know more. Today, the defense will present you with our case, and you will see the unbiased facts of it. You will see the hard evidence, and you will see Avery Becker is not guilty. We will present you with a suspect with more real-life motive than Avery Becker, who was never thoroughly investigated, and we will show you the unrealisticness of our client committing this crime. Now today, Avery Becker, a smart, bright, young teenager, will be convicted of felony murder if you simply walk blindly into this case. Now we know Avery Becker is innocent, and we ask you to see her as not guilty. Thank you.
Thank you. People, are you ready to call your first witness?
Yes, Your Honor. I would like to call Kyle Kuzak to the stand.
Begin when you're ready.
Good morning. Please state your name and spell your last for the record.
Kyle Kuzak, Kuzak.
What do you do for a living?
I am a Colorado Bureau of Investigation's certified crime scene reconstruction investigator, also known as CSR, and I've spent my last 3 years with the city of Denver.
What is a crime scene reconstruction investigator?
I investigate complex crime scenes, homicides, domestic violence, burglaries, things of that nature.
How long have you been doing your job?
I have 19 years of experience in this occupation.
Your Honor, I move to qualify Kyle Kuzak as an expert in crime scene reconstruction investigation.
That was crime scene reconstruction investigation.
Yes.
All right. Any objection or voir dire?
Yes, Your Honor. May I perform a brief voir dire? Thank you. You haven't testified to any education today, have you?
No, I have not.
You haven't testified to any formal training outside of conferences, have you?
No.
Okay. Thank you, Your Honor. I do not object to this witness being entered as an expert.
You have no objection?
No objection, Your Honor.
All right. Then she shall be accepted as an expert in crime scene reconstruction investigation. You may proceed.
What is your role in this investigation?
I investigated the scene of the homicide after it was processed by other members of the crime lab. I also reviewed police reports, photos taken of the crime scene, as well as the ring security videos.
What day did the crime being discussed happen?
Based on our investigations, March 6th, 2020.
Based on your investigation, what happened on the afternoon of March 6, 2020?
We believe this is obviously a burglary gone bad. The intruder entered the house and was then met by the victim, who had grabbed a weapon to defend himself, and unfortunately during the ensuing struggle ended up getting killed with the same weapon he introduced to the encounter.
So how did the suspect enter the home?
Well, first the intruder attempted the front door of Mr. Brackman's home. When that attempt failed, he went around the back gate and entered through the back door of the residence.
Did Mr. Brackman allow the intruder to enter his home?
It seems that the entrance was indeed unauthorized, as Mr. Brackman had a ring security system and he would have been notified to the presence of an intruder at his home, and if someone was at his house, he would have been able to let him in himself.
What happened after the suspect entered Brackman's home?
After the suspect entered Mr. Brackman's home, he had grabbed a weapon to defend himself, and during the struggle caused scuff marks as well as a broken plate, and then Mr. Brackman was then stabbed in the shoulder.
Your Honor, permission for a witness to view Exhibit 8. Let the record reflect that I'm showing the witness what has previously been marked as Exhibit 8. Do you recognize Exhibit 8?
Yes, I do.
What is Exhibit 8?
It is a picture of a knife block with a knife missing found in Mr. Brackman's kitchen.
How do you know?
This was the picture I reviewed during my investigation.
Is Exhibit 8 a complete and accurate copy of the document you reviewed?
Yes, it is.
Your Honor, I move to admit Exhibit 8.
Any objection?
No objection, Your Honor.
Shall be admitted.
What do you notice about the block?
There seems to be a knife missing from one of the knife slots.
What type of knife would fit in that spot?
Most likely a large chef's knife.
Let the record reflect that I have stopped showing Exhibit 8. What type of knife did you find to be the murder weapon?
A large chef's knife as well.
Based on your investigation, how was the victim stabbed?
Based on our investigations, the victim was stabbed in a bear hug-like fashion, and when the knife entered his shoulder, it nicked the tip of his aorta, causing him to bleed internally.
Your Honor, permission for a witness to view Exhibit 18?
Certainly.
Let the record reflect that I'm showing the witness what has previously been marked as Exhibit 18. Do you recognize Exhibit 18?
Yes, I do.
What is Exhibit 18?
It is a picture of the scuff marks that were found near the back door on the floor in Mr. Brackman's home.
How do you know?
I reviewed this picture during my investigation.
Is Exhibit 18 a complete and accurate copy of the document you viewed in your investigation?
Yes, it is.
Your Honor, I move to admit Exhibit 18.
Objection to the admittance of Exhibit 18.
No objection, Your Honor.
All right. It shall be admitted into evidence, and we'll constructively assume the jury can now see it.
What do these scuff marks suggest?
These scuff marks suggest that there was indeed a struggle that occurred in the house.
Let the record reflect that I have stopped showing Exhibit 18. Your Honor, permission for witness to view Exhibit 9.
Certainly.
Let the record reflect that I'm showing the witness what has previously been marked as Exhibit 9. Do you recognize Exhibit 9?
Yes, I do.
What is Exhibit 9?
It is a picture of a broken plate that was found on the floor in Mr. Brackman's home.
How do you know?
This is the picture I reviewed during my investigation.
Is Exhibit 9 a complete and accurate copy of the picture you reviewed?
Yes, it is.
Your Honor, I move to admit Exhibit 9.
Any objection?
No objection, Your Honor.
9 shall be entered into evidence, and the jury will constructively be able to see it now.
How do you think this plate broke?
I believe that during the struggle, one of the two hit the table, causing the plate to break, or possibly one of the two laying a hand on the plate and throwing it off the table in an angry fashion sort of way, causing it to break on the floor.
Let the record reflect that I have stopped showing Exhibit 9. Based on your investigation, was the home invasion planned?
We do believe that the home invasion was planned, but we do believe it was intended to be a burglary home invasion, not a homicide.
How did the victim die based on your investigation?
Well, when the knife entered the back of his shoulder, the tip of the knife nicked his aorta, and when the victim removed the knife from his shoulder, it caused him to bleed internally, which would have caused him to die before he hit the ground.
Thank you, Your Honor. No further questions.
Right, cross-examination?
Thank you, Your Honor. You investigated the scene at 444 South Flower Street, right?
Yes, I did.
And when you got there, you saw a body?
Yes, I did.
And you saw a knife, right?
Yes, I did.
Okay, and you reviewed all the police photos for this investigation?
I did, yes.
And would you recognize them if shown to you today?
Yes, I would.
All right. Your Honor, permission to screen share Exhibit 1 with this witness.
Certainly.
Thank you, Your Honor. All right. Do you recognize this exhibit?
Yes, I do.
And what is it?
It is the picture of Mr. Brackman's body on the floor in his home.
All right, let the record reflect. I'm now scrolling down to Exhibit 2. This is also one of the police photos. Do you recognize this?
Yes, I do.
And what is it?
It is a picture of Mr. Brackman as well as the wound to the back of the shoulder.
All right, thank you. I'm now scrolling down to Exhibit 3. Do you recognize this exhibit?
Yes, I do.
And what is it?
It is a close-up picture of the wound on Mr. Brackman's shoulder.
All right, thank you. I'm now scrolling down to Exhibit 4. Do you recognize this exhibit?
Yes, I do.
And what is it?
It is Mr. Brackman's body as well as the knife wound.
Okay, thank you. Your Honor, I now ask to admit Exhibits 1 through 4 into evidence.
Objection to admitting Exhibits 1, 2, 3, and 4 into evidence.
No, Your Honor.
All right, and Exhibits 1, 2, 3, and 4 will now be admitted into evidence and will constructively be shown to the jury.
Thank you, Your Honor. All right, investigator, your theory is Mr. Brackman pulled the knife out of his own back, correct?
Yes, we found that very, very possible.
Okay, and you believe that he dropped the knife right as he pulled it out of his back, yes?
Yes, we do believe that could be.
Okay. Investigator, you can't see a knife in this photo, can you?
No, I cannot.
Okay, and scrolling down to Exhibit 2, you can't see a knife in this photo either, can you?
I cannot, but that does not mean that the knife was outside the scope of the picture.
Okay, scrolling down to Exhibit 3, you can't see a knife in this photo, can you?
No, I cannot.
Okay, and now Exhibit 4, there's no knife in this photo either, is there?
No, there is not.
Okay, thank you. Let the record reflect I'm now stopping my screen share. All right. Investigator, you believe that the murder weapon came from Mr. Brackman's knife block, correct?
Yes, we do believe that.
But you are aware that the knives in the knife block are a different brand than the murder weapon, yes?
Yes, but it is not unlikely that the knife could have been replaced.
Okay, thank you. And let's talk a little bit about your theory of this bear hug type struggle motion. You believe that the intruder and the victim got in some kind of a bear hug while they were struggling, yes?
Yes.
Okay, and you believe that the intruder was somehow able to get the knife over Mr. Brackman's shoulder into his back 7.5 inches, correct?
Yes,
Okay, thank you. You reviewed the ring videos for this case, right?
I did.
Okay. And you can see an intruder on them, yes?
Yes, you can clearly see an intruder on the security videos.
Okay, but you can't tell the height of this intruder just by looking at the videos, can you?
We cannot tell the exact height based on the security videos, no.
Okay, you can't see any identifying marks on them, right?
No, there's no sign of identification.
Okay, you can't tell race, can you?
No, we cannot.
You can't tell gender, can you?
No.
Okay, thank you. You could say that the intruder has a pretty average build, right?
Yes, pretty average, yes.
Okay, and you would also say Avery Becker has a pretty average build?
Yes.
Okay, thank you, Your Honor. I have no further questions.
Any redirect examination?
Yes, Your Honor. After viewing ring footage, did it appear that the suspect was carrying a knife?
No, it appeared that he was not.
Did it seem they carried a bag that could hold a knife?
No.
Thank you, Your Honor. No further questions.
All right, I know I previously said I don't typically allow recross, but I've been considering that. Is there any recross examination?
No, Your Honor, thank you.
All right. Then this witness may be excused. People, please call your next witness when you're ready.
I would like to call Ms. Cifuentes to the stand. Ms. Cifuentes, please introduce yourself to the jury by stating your name and spelling your last name for the record.
My name is Alex Cifuentes, Sifuentes.
How do you know the defendant, Avery Becker?
I know Avery in a variety of ways. We went to the same high school. We were on the mock trial team together. Avery was actually the one who told me to try out for mock trial. And because both of those things are such a big time commitment, we got to be pretty close friends.
Can you just explain what is mock trial?
Mock trial is a little bit hard to explain in summary, but it's basically going through trials, being attorneys and witnesses without actually being in the legal system.
Was the defendant talented at mock trial?
I mean, mock trial is a big thing. There's a variety of areas to be talented in. So in preparation and work ethic, Avery sometimes fell short in those areas, but Avery was extremely talented at improvising and performing.
Now let's discuss Mr. Brackman. Who is Mr. Brackman?
Mr. Brackman was our mock trial coach and a local defense attorney. But for me personally, he was a person who really cared about his students and was a really big role model for me in my life.
What did you observe the relationship between the defendant and Mr. Brackman to be like?
They had a bad relationship, to say the least. They got in arguments pretty much every single mock trial practice, and it always seemed to me like they were incredibly frustrated with each other.
Are there any particular arguments that you remember?
I mean, there were a lot of arguments, but one that I remember just because of how horrible it was is right after the regional tournament, Mr. Brackman and Avery got in an argument yet again, and Avery stormed out of the room with a permanent marker looking pretty angry. And from what I learned later, she vandalized Mr. Brackman's car once she got outside.
What did Mr. Brackman do in response to the vandalism?
He removed Avery from the mock trial team completely, which was understandable, but it kind of put the team in a really tough position because we were headed to state and mock trial says you can't just substitute another person in at the last minute. So it meant we were probably going to have to forfeit.
Did you ever discuss this with the defendant?
Yes, Avery reached out to me via text shortly after asking if I would be willing to.
Objection, Your Honor. Facts not in evidence.
Response?
Your Honor, these facts are testified to in the witness's prior statement.
May I respond, Your Honor?
So what I believe your objection is that this has not been testified to previously here today.
My objection is that the supposed text messages that they're talking about have not been admitted into evidence, and since they are talking about what directly is inside of them, that isn't allowed because it hasn't been published.
Right, your response on those grounds.
The witness isn't talking about what's inside the evidence, the text messages. She's just discussing that they happened.
Your Honor, may I respond?
No, at this time I'm going to overrule and allow you to continue questioning.
Ms. Cifuentes, would you like me to repeat the question?
Yes, please.
Did you ever discuss this whole vandalism incident with the defendant?
Yes, Avery reached out to me via text, just sort of communicating with me about wanting to get back on the team, and that's the extent of our conversation, pretty much.
All right. Your Honor, permission for the witness to view Exhibit 14?
Certainly.
Let the record reflect that I am showing the witness what has previously been marked as Exhibit 14. Ms. Cifuentes, do you recognize Exhibit 14?
Yes, I do.
What is Exhibit 14?
Exhibit 14 is the screenshots of the text messages I was talking about.
How do you know this?
I was the recipient of these text messages as well as I took the screenshots myself.
Is Exhibit 14 a complete and accurate copy, accurate printout of the text messages?
Yes, it is.
Your Honor, I move to admit Exhibit 14.
Objection?
Yes, Your Honor, I object to Rule 901 and 801.
Start one by one. Response to 901.
Your Honor, can I have clarification as to what the objection is under 901?
Defense, if you'd like to clarify, please.
Yes, so 901 is the hearsay objection, so I'm objecting to hearsay. And in regards to 801 is hearsay. In regards to 901, that's authentication of a document or evidence.
All right, so under 901, you're objecting to the authenticity of this document?
Yes, Your Honor, I'm objecting to the yes.
All right, your response from the people.
Your Honor, as it clearly states at the top of the screenshot, these messages clearly came from Avery Becker, and any argument about their authenticity should go to weight, not authenticity.
Your Honor, may I respond?
Briefly.
There has been no proof or foundation laid that this is Avery Becker besides the imprint of her name. There's been no timestamps of when these were sent, what days they were sent, and if the defendant actually sent these, and the defendant has not confirmed either in their affidavit or verbally today that they sent these text messages, and there has also been no response to the hearsay objection.
Yes, we were handling them one at a time. So in terms
Oh,
of
okay, I'm sorry.
No, you're fine. In terms of 901, I am going to overrule on those grounds. Next, we'll move to the 801 objection, your response to hearsay from the people.
Can I have clarification as to what statements are being objected to?
Yeah, so let's first of all break this down into a couple parts here. We've got some statements from Avery Becker and some statements from Alex Cifuentes. So let's start with the Avery Becker statements. Ms. Thompson, are you objecting to the statements made by Ms. Becker?
Yes, I am, Your Honor.
Your response, Ms. Bensley, to the statements from Ms. Becker?
Ms. Becker's statements are admissible as an opposing party statement under Rule 801 D2.
So that objection will be overruled. Next, we're going to move to the statements from Alex Fuentes. We've got 4 text messages here. Ms. Thompson, are you objecting to all 4 of those statements?
Yes, I am, Your Honor.
All right, so Ms. Bensley, your response to those 4 texts.
Yes, Ms. Cifuentes' statements are not hearsay because they're being used to provide context for the defendant's statements and for the effect on the defendant, but not for the truth of the matter asserted.
Your Honor, may I respond?
You may.
There is no exception to provide context to a situation because Ms. Cifuentes' statements are an out-of-court statement. It's still considered hearsay. And if this is not coming in for the truth of the matter asserted, what she said in turn gave Avery the response that she put, whether or not this was Avery. And so effect on the listener does not apply in this circumstance.
So, pardon me. First of all, I'm going to break these statements down here. I don't think you're using, hey, what's up for the truth of the matter asserted. Next, I've got, I don't know, coach is still pretty upset with you. My understanding, oh my God, I guess I could try, but the car situation, I doubt anyone could change his mind. So those 2 statements, last one is, what are you going to do to his house? That's clearly a question, not a statement. So for these last 2 statements, Ms. Bensley, correct me if I'm wrong here, you're saying you're using these for the effect on the listener, not for the truth of the matter asserted?
Yes, Your Honor.
All right, and the subsequent part of that is effect on the listener and subsequent action. So I am going to overrule the objection. This exhibit will be admitted into evidence. That's Exhibit 14, and it shall be constructively shown to the jury at this time.
Thank you, Your Honor.
Ms. Cifuentes, can you please read the last 2 messages you received from the defendant?
Yes, do you want me to read the last 2 on this page or the next one?
Objection, Your Honor, Rule 403.
Are you objecting that this is cumulative?
Yes, Your Honor.
All right. Your response to this being cumulative, Ms. Bensley?
Your Honor, I am just having the witness discuss what she has seen in this exhibit. I don't believe it would be cumulative.
Ms. Thompson, in your response?
Yes, Your Honor. Reading from an exhibit that's already been published to the jury is cumulative because they already have access to the evidence and they're able to read it themselves. Reading it out loud right now is a waste of the jury's time.
My understanding of Rule 403 is that simply highlighting certain portions is not cumulative. It is unnecessarily overly cumulative. If she were to read this entire document with no context, that would certainly be cumulative. Having her highlight certain sections and then ask the witness about those sections is not cumulative, and I will overrule the objection at this time.
Thank you.
Ms. Cifuentes, would you like me to repeat the question?
Yes, just clarify which 2 messages I'm supposed to be reading.
Yes, please read the last 2 messages on this second page that you received from the defendant.
Of course. Avery texted me saying, I'm going to wait until he's at work, then break in and trash it. That being in reference to Mr. Brackman's house. That'll show him was the last message I received.
Ms. Cifuentes, did you share this conversation with anyone?
I only shared it with Detective Markowitz. When I first got these messages, I didn't really think Avery was serious. I thought she was just kind of upset, blowing off some steam. And then it wasn't until after Detective Markowitz contacted me that I realized Avery must have actually been serious.
Ms. Cifuentes, did you fake these text messages?
No, of course not. I would never do that.
Thank you, Your Honor. No further questions.
Thank you. Cross-examination?
Yes, Your Honor. Good morning, Ms. Cifuentes.
Good morning.
We're going to start off by talking about Avery Becker. You consider the defendant Avery Becker to be your best friend?
Avery's a close friend of mine, in my opinion, yeah.
And you guys hung out outside of practice?
It was mostly within practice, but there were a couple events that were related to a mock trial that weren't the actual mock trial practice where we would.
So just to clarify, just to clarify, you never hung out outside of practice unless it was for mock trial?
I'm not entirely sure, but I do believe that would be a fair assumption.
So is that a yes?
Yes, I believe so.
We're going to talk a little bit more about your relationship with the defendant. You still claim that you're best friends, even though you guys never hung out outside of practice unless it was related to mock trial.
I mean, mock trial is a big time commitment, so you spend a lot of time together. So yeah, that's primarily where our relationship came from.
And you're here today testifying against Miss Becker, your best friend.
Yeah, I mean, just because Avery's my best friend doesn't mean I'm gonna lie in a murder
But
trial.
just to clarify, that was a yes.
Yes.
We're going to talk a little bit about the text messages. You had an interview with the police.
It did. I had an interview with Detective Markowitz.
And in that interview, you allowed them to have your phone?
I didn't bring my phone with me. I completely forgot it. So I did talk to Detective Markowitz about the content of the text messages, though, however.
So Detective Markowitz was never able to actually see your phone?
He didn't see my phone, but I sent him screenshots of the text messages.
So you only sent screenshots and there was no other proof that these text messages were valid?
I mean, they are valid, so.
But you're aware that there are ways to manipulate text messages?
I mean, I guess so. I wouldn't really have any experience in knowing that, though.
But you're aware that there are?
I'm sure there are. I'm sure there's ways to manipulate most digital files.
Ways like changing a contact name?
Objection, Your Honor, relevance.
Your response to relevance?
Yes, Your Honor. This text messages, in the prosecution's eyes, establish motive, and I'm establishing the validity and how these text messages came about because they were a key piece of evidence in the detective's case.
Bensley, any response?
No, I just stand by my previous objection to relevance.
Given that relevance is a low bar, I am going to overrule and allow this questioning. If it does seem to go too much further or into an area that becomes irrelevant, please do re-raise your objection.
Repeat your question, please.
Yes, so you're aware that there's ways to manipulate text messages, such as changing a contact's name?
I mean, as I said, I don't have experience manipulating.
But you're aware that there is?
I mean, not really. I don't have experience with it, so I don't know what you can do.
Let me break this down for you. So you're aware that you can change a contact's name?
I mean, I'm sure you could.
And you're aware that you could text somebody through another person's contact's name and change it?
I'm confused on your question.
Sorry, I will rephrase. You're aware that you can change a contact's name and text and have a text conversation to make it look like somebody else?
I'm sorry, I'm still confused. You seem to have like two parts and I'm not really sure which part you're asking.
You're totally fine. We can move on from there. So we're going to talk a little bit about the day of March 6th. You don't tell us where you were on March 6th, do you?
No, but I can tell you now if you would like me to.
You were at school, is that correct?
Yes, it was a Friday, so I was at school.
And you state in your affidavit that you were at school, just to clarify for the jury.
I'm not sure if I put it in my affidavit. I didn't really think my whereabouts on that day were relevant.
You didn't believe it was relevant to put your whereabouts on the day of the murder?
No, because my affidavit wasn't given as me being involved in any other way other
So
than
that was a no,
relationship.
just to
No.
clarify.
No,
That was a no.
think it was relevant.
So the jury will not be able to hear today where you were on the day that Mackenzie Brackman was murdered.
I mean, I can testify to it today if you would want.
But just to clarify, they won't be able to hear where you were on March 6th, the day of the murder.
Not if I'm referencing my affidavit, no.
And you didn't put in your affidavit where you were?
No, I didn't. I didn't think it was relevant.
Because you said you were at school, right?
I was. It was a school day, so of course I was at school.
You wrote an affidavit in this case?
I'm sorry?
You wrote an affidavit in this case?
I wrote an affidavit in like regards to the murder or in regards to my whereabouts?
You wrote a statement about this case,
I did.
about your side of the case,
I
and in
did.
that you put all relevant and true facts.
Yes, I did.
One moment as my co-counsel screen shares what has been previously marked as Alex Cifuentes' affidavit. Nowhere in your affidavit, Ms. Cifuentes, do you
Your
state
Honor.
that you were...
It is unclear why my witness is being impeached.
All right, your response to the impeachment objection?
Yes, Your Honor. Ms. Cifuentes clearly stated previously that she was at school on March 6th, and I am merely aiding the jury's understanding through her affidavit.
Hensley, response?
In your questioning, my witness did say that she was at school on March 6th. I don't understand why you need to show it to the jury now.
Your Honor, may I respond?
May.
In Ms. Cifuentes' affidavit, as will be shown, she did not state that she was at school on March 6th.
Right, I'm going to allow some leeway on here. You may continue overrule any objection. You may continue with the impeachment.
Thank you. Ms. Cifuentes, does this appear to be a clear and accurate copy of your affidavit?
Yes, it is.
And I'm going to scroll down to the last page. One moment, please. Is that your signature at the bottom?
Yes, it is.
And just to clarify, nowhere in your affidavit do you state that you were at school on the day of March 6, 2020.
I believe I've already told you multiple times that I didn't include it in my affidavit because I didn't think.
But your prior statement was that you were at school on March 6th. Is that correct?
Yes, it was.
Thank you, and co-counsel can stop screen sharing. So you did not believe it was relevant nor important to state where you were on the day of the murder?
No, why would it be?
Thank you, no further questions.
All right, any redirect examination?
Yes, Your Honor, briefly. Ms. Cifuentes, would you manipulate these text messages?
No, I would have nothing to gain by manipulating them, and I don't even know how to do that.
Thank you, Your Honor. No further questions.
Any recross based on that one question?
Yes, Your Honor, a brief one. Ms. Cifuentes, as previously stated, you are aware that there are ways to manipulate text messages.
I know that there are, but I don't know how to
Asked
do
and
it.
answered.
Thank you, no further questions.
I'm going to sustain that objection, especially given that the question was as stated before. Any other recross?
No, Your Honor.
All right. This witness may be excused. The people may call our next witness.
The prosecution calls Detective Jordan Markowitz to the stand.
All right. And Ms. Wright, you may begin when you're ready.
Good morning, Detective Markowitz. Please state your name and spell your last for the record.
Jordan Markowitz, Markowitz.
Detective Markowitz, what do you do for a living?
I work for the Denver Police Department. I've worked here for 13 years, and I'm a detective there. I've been a detective for 7 of those 13 years.
Do you have any specialized training?
Yes, I do. I have specialized training in cell phone technology as well as forensic data recovery from the American Academy of Law Enforcement.
What did that training involve?
That training involved learning how to download different types of cell phone data, how to use systems to acquire data, such as the Celebrite system, how to download and interpret data from cell towers. And to get these certifications, I had to complete a 3-day training course as well as pass a certification test.
How many cases have you used your knowledge of cell phones on?
Oh, I use my knowledge constantly as a detective. I've downloaded the contents of literally hundreds of cell phones, and I believe I've used my knowledge in over 50 cases.
Your Honor, at this time, the prosecution moves to tender Detective Jordan Markowitz as an expert in cell phone technology, as well as forensic data recovery.
All right, so that was cell phone technology. And what was the other one?
Forensic data recovery.
Forensic data recovery. All right. Any response or voir dire?
No objection to either, Your Honor.
And so then he shall be admitted as an expert in cell phone technology and forensic data recovery.
Let's talk about the case. What relation do you have to this case, Detective Markowitz?
In March 2020, I was assigned to investigate the death of Mackenzie Brackman.
At what point did you arrive on the scene?
After uniformed officers secured the scene, I responded at approximately 2:20 p.m.
What were your first impressions of the scene?
You know, the victim was laying deceased just inside the home. His upper left shoulder area was soaked in blood. There's a large knife wound, and there's a knife just in front of his body.
As you observed the body, did you recognize him?
Not at first. After I saw his identification, I did recognize him as Mackenzie Brackman, a criminal defense lawyer.
I'd like to move on to what you did after you recognized the body. Did you at any point in time enter the house?
Yes, I did. I went around the house and entered through the back.
What did you notice upon inspection of the house?
Upon inspection, everything was maybe in a slight disarray. I couldn't tell if that was from a struggle or just in the normal state of the home. And nothing was stolen. There were several expensive laptops and televisions, and they were also there, which was peculiar.
Moving back to the victim, what do you know about Mr. Mackenzie Brackman?
I knew that he was a criminal defense lawyer, and I had the displeasure of being crossed by him several times.
Did you recover any information from the scene?
Yes, I did. I recovered the victim's cell phone. I was then able to see that he had numerous emails relating to something called mock trial. I believe he was a coach for the local school. So I contacted the school and got a list of contacts for the mock trial participants.
After obtaining the list of mock trial students, did you contact anyone?
Yes, I did. I contacted student Alex Cifuentes.
What information did Ms. Cifuentes give you?
Well, Ms. Cifuentes informed me of numerous text messages that a student named Avery Becker had sent them.
What did you do after learning about those text messages?
After learning about these text messages, I asked to have an interview set up with Cifuentes and their parents.
What information did that interview give you?
That interview gave me very important screenshots that were very helpful in this case.
After talking to Cifuentes, did you contact anyone else?
After talking to Cifuentes, I contacted Avery Becker and arranged to have a meeting set up immediately.
Did you end up having an interview with Ms. Becker?
Unfortunately,
Ms. Becker?
Unfortunately, no, I did not have an interview with Ms. Becker. Just before the interview was scheduled, her lawyer contacted me and said that the interview would be canceled and that all further communications would have to go through her.
Did you take any further action after hearing this news?
Yes.
Objection, Your Honor. Vague. I'm objecting on the grounds of vague, just to ask opposing counsel to be a little clearer and more direct in their line of questioning here so the jury can follow.
Right, any response?
Your Honor, I am confused by the objection. As this is a direct examination and an expert witness, I am allowing the witness to answer the open-ended questions as he feels necessary.
Your Honor, if I may respond. I stand by my vague objection as there's lots of information being gained from this examination. And so as opposing counsel is going through this examination, I just ask them to be more clear in an effort to not confuse the jury.
I'm going to overrule at this time and allow Ms. Wright to ask the questions as she sees fit. And if Detective Markowitz has any issues, I do expect him to ask for clarification.
Okay, thank you, Your Honor.
Would you like me to re-ask the question?
Yes, please.
After talking to Cifuentes, did you contact anyone else?
After talking to Cifuentes, yes, I contacted student Avery Becker and arranged to have a meeting set up immediately.
Did you end up having the meeting with Avery Becker?
Unfortunately, no. Just before the scheduled meeting, the lawyer contacted me and said that the interview would be canceled and that all further communications would have to go through her.
Did you take any further action after hearing this news?
Yes, I did. I obtained a warrant to search Becker's cell phone, but when I contacted the lawyer said that Becker had lost the phone and was no longer in possession of it.
Did the attorney provide you with any resources regarding the phone?
Yes, the attorney fortunately did provide me with Becker's cell phone number.
Now, Detective, I'd like to move on and talk about what you did with that cell phone number. What are call detail records?
Basically, whenever an interaction with the phone happens, such as a call is placed or received, a text is sent or received, a record of this event is created and stored in a cell tower.
What do you do with these records?
You can do a few things with these records. First of all, you can determine, like when a call was placed or received, same thing with the text. You can also determine the location of a person based on which cell towers their phone connected to.
How are cell towers used to track a person's location?
Well, a phone is programmed to connect to the nearest cell tower. This isn't always the case, though. If the cell tower is full, for example, it'll connect to a further one, perhaps, but usually it connects to the nearest one. So based upon which cell tower is the phone connected to, you can determine the location of a person because they're in the range of that cell tower.
Can you explain the types of calls that Avery Becker's phone was receiving the day of the murder?
So Avery Becker's phone was receiving numerous calls, very short. They were so short, in fact, that Becker could not have been picking up. And the calls were all from a student named Taylor Perkins.
Did the calls continue all day?
No, the calls stopped shortly after the murder. We can assume that the phone was turned off, put in airplane mode, or perhaps even destroyed.
Your Honor, permission for the witness to view Exhibit 15?
Certainly.
If the time could briefly be paused for technical difficulties.
That would be fine. If you guys could both pause. Then we'll resume once you're ready. I saw
Okay.
paused in the chat. Thank you very much.
The time can be unpaused now. Thank you.
Thank you.
Let the record reflect that I am sharing my screen with exhibit that has previously been marked as Exhibit 15. Detective Markowitz, what is Exhibit 15?
Well, Exhibit 15 is a diagram that I created of the cell towers that Becker's phone connected to on March 6th.
How do you know?
Because it's a diagram that I myself created.
Did you use this diagram in forming your opinion on this case?
Of course. It's extremely important. The call detail records can pinpoint where Avery was.
Is this a complete and accurate copy of the call detail records that you achieved from Avery Becker's phone on the day?
Yes, it is.
Your Honor, at this time, the prosecution moves to admit Exhibit 15 into evidence.
Any objection?
No objection on the entrance of this exhibit, Your Honor, but I do ask that if opposing counsel is going to discuss this exhibit further, that they lay proper foundation to show that Avery was in possession of her phone on March 6th, and so we know that we can track Avery Becker through these diagrams, because from what we know now, we can only track the location of her phone. But at this time, no objection.
we're going to do is we'll admit Exhibit 15 into evidence. The jury can now constructively see it. What my ruling is going to be in terms of the second issue, what I'm going to say is I believe the people are free to discuss that Miss Becker's phone was in this area. And then the issue of whether Miss Becker had the phone in her possession or not is going to be a matter to be discussed in closing argument. But
Yes.
if it goes too farther, please feel free to raise any objection at that time.
Okay, thank you, Your Honor.
Detective Markowitz, what does this diagram show?
This diagram shows the cell towers that Avery's phone connected to, and the route that they would have taken to Mackenzie Brackman's home.
Objection, Your Honor. I raise my lack of foundation objection now as the detective is testifying that Avery moved along this route when we only have the foundation laid to show that Avery's phone moved along this route.
Ms. Wright, your response?
Your Honor, as this witness is an expert, this falls under expert opinion, and it is this expert's opinion that while the phone was taking that route, that Avery Becker was the one in possession of that phone.
To clarify, he is an expert in cell phone technology and forensic data recovery. Can you explain more how whether or not Miss Avery had the phone falls under that expertise?
Your Honor, I believe that the detective's response to the question phrased it as Avery Becker's phone was the one that connected to the tower, which would show what Avery Becker's phone's route would be. If that was not how he would answer, I would like to rephrase the question that I asked.
Is there any response?
Yes, Your Honor. The detective stated that they, assuming that means Avery, moved along the route that they believed led to Mr. Brackman's house. And so they did, in fact, testify that Avery supposedly moved along this route. Would you like me to also object or respond to the 705 response, or is that sufficient?
That is sufficient. What I believe what I'll do at this time is I'm going to sustain the objection insofar as the detective should not say whether or not that was Avery, but just what the phone was doing. So Ms. Miller, Ms. Wright, allow you to re-ask the question and instruct Detective Markowitz to answer accordingly.
Yes, Your Honor. In relation to Avery Becker's phone, what does this diagram show?
This diagram shows the cell towers that Becker's phone connected to, and where Becker's phone was on the day of March 6th, 2020, the murder.
To summarize, what do you believe that the call detail records for this case prove?
Well, to summarize, I believe that between 12:45 and 12:50, Becker's phone was at home, and between 12:50 and 1, Becker's phone was in the car moving down Rock Creek towards Mackenzie Brackman's home, and between 1 and 1:17, Becker's phone was at Mackenzie Brackman's home of residence.
Based on the evidence provided and your experience as a detective, what do you believe happened the day of the alleged murder?
Based off of the evidence I was given to work with, as well as my experience as a detective, I am certain that on March 6th, 2020, Avery Becker broke into Mackenzie Brackman's home with
Objection, Your Honor. Lack of foundation once again. Would you like me to explain?
Feel free to explain, yeah.
Okay, I'm objecting on the grounds of lack of foundation, as once again, we don't have ample foundation to show that Avery was in fact present at 444 South Flower Street on March 6, 2020. While opposing counsel may try to use 705 to address this objection, 705 only allows experts to state an opinion without first testifying to the underlying facts or data, but there is no underlying fact or piece of data that shows that Avery was present at 444 South Flower Street on March 6, 2020.
Right, your response?
Your Honor, this witness's opinion is based off of the evidence that he collected from the student Alex Fuentes, as well as his experience just as a detective. Therefore, it falls under expert opinion. It is a valid opinion.
So what I'm going to find here is that we're in two kind of different areas. We're in one stating sort of the facts and what Detective Markowitz saw when we're talking about just the phone. Now that we've moved on to his expert opinion in this case, I am going to allow him to opine as to what that means and what his opinion of that phone is and how that relates to the other facts he's read in this case. I will overrule the objection at this time. You may re-ask your question or continue answering.
Okay, thank you, Your Honor.
Your Honor, with worries about time, I did not know that I would be able to re-ask my question.
Detective Markowitz is free to just continue answering if that's easier.
All right. As I was saying, I am certain that on March 6th, 2020, Avery Becker broke into Mackenzie Brackman's home with the intent to burglarize, and on that day, they became—
That is time.
Right. Cross-examination?
Yes, Your Honor. Before I begin, could I get a time check for the remaining time for cross-examination for defense?
Certainly.
Thank you.
8 minutes, 52 seconds.
Begin when you're ready.
Okay. Good morning, Detective. You were called to the scene of 444 South Flower Street on March 6, 2020, yes?
Yes, that's right.
And you were called because a passing motorist had called 911 when passing this address.
Yes.
And this passing motorist had called reporting seeing a body passed out on the porch of 444 South Flower Street.
That's right.
But when you arrived, the body was face down, deceased in the home?
That's right. From his perspective, it's not like the body was really far inside the home. From his perspective, it could have looked like he was perhaps on the porch. But just to clarify for the sake of the jury, the body was not on the porch when you arrived? No, the body was not on the porch when I arrived.
Okay. I'll direct your attention to exhibit number 1 now as I ask co-counsel to share.
If you need to stop time while you sort that out, as the timekeeper is to stop for just a moment.
That would be appreciated. Yes, thank you, Your Honor.
Weird, I understand. All right, time can be resumed. Thank you.
All right, just before I begin my line of questioning, I would like to confirm that you can see exhibit 1 here.
I can.
Okay. And so we can see a body deceased laying face down in this photograph, yes?
That's right.
Okay. And we can see the right arm of the victim in this photograph.
Yes, we can.
Okay. And as I ask co-counsel to scroll down just a little bit, we can see the right hand specifically of the victim, yes?
Yes.
Okay. And we can see that the right hand is laying directly above the head of the victim?
That's right.
Okay. I'll now ask co-counsel to scroll down to exhibit number 4. And here we can see the same body laying deceased on the floor, yes?
That's right.
We can once again see the right hand of the victim in this photograph, yes?
Yeah.
Okay. And we can see that the right hand is laying directly to the side of the victim's
Your
head.
Honor, attorney testifying.
Ms. Miller, your response?
Your Honor, this is not attorney testifying. It doesn't qualify as such, as I am just conducting my cross-examination of the detective through asking what is clearly visible in the photographs. If you would like me to give the detective a little more leeway to say exactly what is in the photographs, I'm happy to, but I believe that I'm just stating what is seen in these photos.
That's right. Your response?
Yes, Your Honor. The attorney is providing what is being shown in the exhibit and not allowing the detective to say what he believes is being shown in this exhibit. Therefore, the attorney is giving her opinion of what is being shown.
Your Honor, if I may respond. Oh,
no need
excuse
to.
me,
You're
sorry.
fine. I am going to overrule the objection. At this time, this is cross-examination. Ms. Miller, you're certainly welcome to ask leading questions, even if that is basically a statement, as long as Detective Markowitz is given the chance to say yes or no. You giving statements is fine, so I'll overrule.
Okay, Detective, I'll re-ask my question. In this photograph, we can see the right hand of the victim laying directly to the side of their head.
That's right.
Okay, and so the body is, or excuse me, the right hand is not in the same location as it was in Exhibit 1?
Well, I'm certainly no expert in, that, like the movement of the body. But a lot of people were there that day. We can assume maybe someone got too close and I don't know, something happened. But I'm no expert in that, so I don't know.
Detective, just to clarify, all of the photographs seen here, Exhibits 1 through 4, were taken by members of your team, yes?
That's right.
Okay, and so just to clarify for the jury, these photographs do not contain the right hand in the same place.
That's what it appears.
Okay, speaking of photographs, you and other uniformed officers present at the scene took other photographs while there, yes?
That's right.
But not all of these photographs are available for us to see here today?
Unfortunately, no. Some of them were corrupted. These things happen. It's annoying, but it happened and there's nothing we can do about it.
So some of these photographs became corrupted in the hands of the police?
Objection, Your Honor, relevant.
Relevance?
Your Honor, this is relevant as I'm just clarifying how these photos became corrupted for the sake of the jury. As I'll explain later, these photos were crucial to the crime scene, and so I would like the jury to have ample knowledge of why they were lost and why they're not seeing these photographs today.
Right, any response?
Your Honor, while the pictures that are not able to be seen here are relevant, what led to the pictures not being able to be seen here is not relevant, as well as the police being at the hands of corrupting the files.
I'm going to overrule, finding relevance is a very low bar, and I'll allow you to continue asking questions.
Okay, Detective, I'll just restate my question then. These photographs became corrupted in the hands of the police?
I mean, yeah.
Okay, and these photographs contained images of blood splatter on the walls around Mr. Brackman's body,
Yes, they did.
as well as blood drops around the body?
That's right, yes.
Okay, I will now ask co-counsel to share Exhibit 15 as I direct your attention to it. In just a moment. No need to pause time though. Okay, and just to make sure before I continue, you can see Exhibit 15 clearly here, yes?
Yes, I can.
Okay, and you can see that you've marked the ranges of 3 cell towers, yes?
Yep.
Okay, and looking specifically in the range of that first cell tower, we can see a location marked Becker's house, yes?
Yes, we can.
But we can also see a location marked Rollins' house, yes?
That's right.
Okay. Going back to some of the things discussed on your previous examination, you don't have any evidence that Avery was in possession of her phone on March 6, 2020, do you?
Well, we don't, but we really don't have any evidence that it was stolen or, Yeah. Yeah.
But you did learn in your investigation that Avery Becker had lost her phone on March 5th, 2020.
I don't believe I remember hearing it on March 5th, the date specifically, but I do know that she lost her phone.
But you learned in your investigation that Avery lost her phone on March 5th, 2020.
Like I said, I don't remember hearing a date, but I do remember hearing that she did lose it.
Do you remember putting something in your affidavit regarding Avery Becker losing her phone on March 5th, 2020?
I remember putting
Objection,
something
Your
in my
Honor, improper impeachment.
Your Honor, if I may respond. I'm not moving to impeach this witness. I'm just asking for the sake of clarification. If the detective were to deny and say no to this question, then I would move to impeach. But at this time, I would rather bring up their affidavit for the sake of refreshing their recollection.
Right, any response?
No, Your Honor, but if the attorney does move to impeach my witness improperly, then I will raise my objection again.
Perfect. Then I'll overrule at this time, pending what happens next.
And Your Honor, at this time, I will ask if I can bring up the affidavit of this witness solely for the sake of refreshing their recollection, not for impeachment.
Certainly.
Okay, and I will now ask co-counsel to share then. Okay, and as we find where it says that Avery had lost her phone on March 5th, 2020, just a moment. I believe we have plenty of time, and so no need to stop time here. Okay, and so Detective, you can see here in line 115 that it says Becker had lost the phone on March 5th, 2020, yes?
Yes, that's right. I'm sorry. I misspoke there.
No worries. I just want to clarify for the sake of the jury. Okay, and now moving back to exhibit number 15. And again, I believe we have plenty of time, and so no need to stop time. Okay, and so once again, you believe that Avery went to Mr. Brackman's home on March 6, 2020, based on the CDR records that you obtained?
That's right.
Okay, but those CDRs only show the location of Miss Becker's phone,
Yes, that's right.
not Miss Becker herself.
Yeah, that's right.
Okay, and just one more time for the sake of clarification, you learned that Avery, through your investigation, you learned that Avery had lost her phone on March 5th, 2020, according to her attorney. Your Honor, if I may respond. I was rephrasing the way that I put my question, and so this does not qualify as asked and answered.
Right, your response?
Your Honor, this question has been asked before, and it was almost verbatim how the question was asked previously, and therefore it has been asked and answered.
My recollection is also that these questions were almost identical, unless Ms. Miller, you have any other response.
I do, yes. As the objection was raised, I was just saying that through the words of Ms. Becker's attorney, the detective had learned that Ms. Becker's phone had gone missing. If that is not rephrasing enough, I am happy to not ask the question, but I believe that including the attorney there makes it rephrasing.
Right, I'll overrule this time and allow it with some leeway.
Okay, so Detective, I'll just re-ask the question. Then you learned that Avery Becker had lost her phone on March 6, 2020, according to her attorney, yes?
That's right.
Okay, thank you, Your Honor. No further questions.
Redirect.
Your Honor, I ran out of time, therefore I cannot do a
That's
redirect.
right. I'm sorry about that. All right. Then this witness may be excused. Do the people have any further witnesses?
No, Your Honor, the people rest their case.
I'm going to take just a couple seconds here to let the scoring panelists catch up on anything if they need to. All right. In defense, you may call your first witness when you're ready.
Your Honor, the defense calls Taylor Perkins to the stand. And Your Honor, it appears that both my witness and I are having some video troubles. Is it coming across as such on your side?
Both. Okay, you've just come through. The screens were black. I can see you now.
Okay. It appears that I'm still getting a black screen from my witness. Does it?
Yes, so I can see.
Oh.
All right, now I can see everyone we
Yeah.
need to.
Great. Okay. Please state your name and spell your last for the record.
My name is Taylor Perkins, and Perkins is spelled Perkins.
And do you currently attend school, Miss Perkins?
Yes, I actually go to CU Boulder currently, so I'm super proud to be a buff and be bold.
Did you go to high school, Miss Perkins?
Yes, I did. I went to Colorado High School.
When did you graduate?
I graduated last year, so that was like 2020.
And while at Colorado High School, were you involved in any clubs or extracurriculars?
Yes, I was actually involved in mock trial with my best friend Aves.
Did you have any friendships on the mock trial team, or was it just Avery?
Not any like close friends, no.
And were you and Avery in the same grade?
Yes, we were. We were both seniors, graduating, ready to get out of there, honestly.
Were you on the mock trial team for the entirety of your senior year?
No, I wasn't, because like COVID shut down everything, which was super annoying, and I stepped down from the team.
So was Avery on the team for the entirety of her senior year?
Oh no, she got kicked off of the team, unfortunately.
When she got kicked off, did she do anything to try and get back on?
Oh yeah, she tried everything to get back on. It meant so much to her being a senior, putting in all the work all 4 years. She tried everything to get back on.
Did you do anything to try and help Avery get back on?
Yeah, I talked about ways like that she could get back on the team, but I don't remember like I didn't specifically do anything. I did help her get back on the team though, when she was demoted.
Okay, but just to clarify, did you help her get back on the team when she got kicked off?
Oh yeah, I'm sorry. Yes, we talked through ways.
Okay. And was Avery ever successful in getting back on the team?
No, unfortunately not.
Do you remember any dates or a specific time frame of when Avery got kicked back off on the team and when you unsuccessfully tried to help her get back on?
Yes, it was after regionals that she got kicked off of the team.
Do you remember any specific date of when she was getting kicked off and when you were trying?
I was trying to help her around March 5th.
Okay. On March 5th, did you spend any time with Avery in person?
Yes, we're always together.
What were the two of you doing when you were together that day?
She had came back from mock trial practice after trying to talk to Coach Brackman, but that unfortunately did not work. And so she just came over to my house. We just played on our phones for a little bit. Pretty boring, but like I love Minecraft.
Did you do anything else with Avery after you were playing games on your phone?
No, we like went to the Fry Shack. Oh yeah, there was this like really weird situation with Alex Fuentes that happened at the Fry Shack too.
Did you see anyone that you knew at the Fry Shack? I know you mentioned someone there.
Yes, we did see the whole mock trial team, and they were all being so like sweet and sincere to Avery because they knew like she got kicked off of the team and it meant so much to her.
You mentioned previously that something went bad with Alex Fuentes. Will you explain that to me?
Yeah, of course. So Alex Fuentes was like passively aggressive, being like in a passive aggressive way, being sincere to Avery, and it just didn't brush off well. Avery stormed off to the bathroom, leaving her phone on the table, which was like her third kidney. It was so surprising. That thing was never out of reach. And yeah, so that situation happened. It was a little rocky.
When Avery came back from the bathroom, did the two of you stick around at Fry Shack?
No, I was about to punch Alex Cifuentes in the face, so we headed out as quick as possible. I was trying to get away from Alex.
And as far as you remember, do you remember seeing Avery grab her phone off of that table in which Alex was sitting at?
No, I don't think so.
I'll direct your attention to the next day, the day of March 6, 2020 now. Did you spend any time with Avery on that day?
Yes, me and Avery are always together.
What were the two of you doing when you were together initially that day?
Well, we were going to go to school, but we ditched. Just don't, like, my parents don't know yet, but, like, yeah. Just don't tell that we ditched.
Why did the two of you not go to school that day?
Well, we were trying to look for her phone, honestly, and we couldn't find it in the end, though, so it was a waste of time.
Why were you looking for her phone?
She had lost it the night before, which was a problem.
So did you go to multiple locations to look for Avery's phone?
Yes, we did.
What was the first place that you went?
We went to all the stores at the mall, but we couldn't find it there, and then I also went to check at the Fry Shack.
And while at both of those locations, did you have your phone on you?
Yes, I was constantly calling and texting the phone thinking I would hear it somewhere, but I unfortunately didn't hear it anywhere.
And did you go to any location more than one time?
Yeah, I went to the Fry Shack again to check with the afternoon staff, but yeah, there was no luck in finding it.
And when you went to the Fry Shack that second time, did you have your phone on you then?
Oh yeah, my phone's always on me.
Okay. And so I'll direct your attention to exhibit number 15 now, which I believe has already been entered into evidence, as I ask co-counsel to screen share. And Your Honor, if we may pause time, excuse me, while we're getting this exhibit pulled up.
Certainly.
Thank you. Okay, and it appears that the exhibit is back up, so we should be good to get time going again. Ms. Perkins, can you see exhibit 15 on the screen here?
Oh yeah, it's a pretty little map.
And so you can see that it is in fact a map.
Yes, I can.
And I know you're not an expert, so you won't have knowledge of what these are, but you can see 3 red cones laid over this map.
Oh yeah, I see them, and they like fade out a little bit.
And you can see 2 locations marked on this map, marked the Fry Shack and the mall, looking on like the right side of that exhibit.
Oh yeah, they're not in the red cones though.
Yeah, so just to clarify, you don't see either of these locations in any red area?
Oh no, they're not.
Okay, counsel can stop screen sharing now, thank you. I'll direct your attention back to mock trial now. Did you have a coach on your mock trial team?
Yes, we did.
Who was that?
Mr. Mackenzie Brackman.
And as far as you knew, did Mr. Brackman have any sort of relationship with any student at CHS beyond the kids on the mock trial team?
What kind of relationship? Because I don't think he was dating anybody or like married or anything, so.
Did he ever have any conversations that you knew of or spend time with students outside of school, not on the mock trial team?
Oh yeah, Mr. Brackman actually had a pretty significant relationship with Blair Rollins.
And how did you know of this relationship?
Everybody knew of this relationship because Blair Rollins' dad is actually Mr. Brackman like was an attorney and everything, and he was an attorney for Blair Rollins' dad, and Blair Rollins' dad got sentenced to jail for murder, which is so scary. But I love murder, honestly. I watch Midsummer Murders on Netflix, and it's all super interesting to me.
And as far as you knew, was Blair Rollins friends with any other student at CHS that you knew?
Oh yeah, surprisingly.
Who?
Alex Cifuentes was actually best friends with Blair Rollins, which was super weird because like Blair Rollins had the total reputation of being like a total sociopath or hitman, you could say. And then there was Alex Cifuentes, who had the reputation of being like a kiss up. So it was a weird relationship because they were totally opposite people, honestly.
Okay, I'll direct your attention back to Avery Becker now. What was your relationship with Avery?
Me and Avery were best friend. I like to call her Aves sometimes. So, yeah.
And as mentioned previously, did you step down from the mock trial team for Avery?
Yeah, I did, but it didn't really mean anything to me because like I didn't want to be a lawyer, and I was only there because Aves was there, and like when she was demoted down to the B team, I didn't really have a purpose in staying.
Did you feel any regret or remorse after stepping down from the team?
Oh no, it just put less stress on me, which I needed.
Thank you, Your Honor. No further questions at this time.
Cross-examination?
Yes, Your Honor. Good morning, Ms. Perkins. The defendant, Avery Becker, is your best friend.
Yes, me and Avery are best friends.
Avery is the reason you were a part of mock trial?
Yeah, because I just wanted to hang out with her after school, but I would have rather just honestly spent the time with my other friends.
Avery was talented at mock trial?
Oh yeah, she was the best on the team, and I actually wasn't too shabby myself.
You think Avery was the best attorney on the mock trial team?
Yes.
You stepped down from the mock trial team so Avery could have their spot back on the A team?
Yes, I did. Aves honestly were best friends and everything, so I just wanted to give her my spot because I knew how much it meant to her, and honestly, I don't want to be a lawyer in the end, so it doesn't really matter.
Even though you were a senior who had also been on the team for 4 years?
I haven't really been on the team for 4 years. I was a senior and everything, but yeah.
I'm sorry, you said you joined mock trial when Avery joined mock trial, correct?
Yeah, me and Avery joined mock trial.
So were you on the mock trial team for 4 years?
I don't really remember. I don't think I was though, not all 4 years. And I didn't even write it in my affidavit.
Do you know how many years Avery was a part of the mock trial team?
Yeah, I think she was a part of the mock trial team for a while.
We'll continue. Avery vandalized Coach Brackman's car?
Yes, unfortunately, she ruined the paint on his car. She always played pranks on him, and you could always see the steam coming out of his ears.
Objection, Your Honor. Lack of foundation.
Ms. Bensley, your response?
I believe opposing counsel has opened the door to this line of questioning on the direct.
Your Honor, if I may respond.
May.
I raised no questions to Ms. Perkins regarding the vandalization of any car on direct, and so proper foundation has not been laid to show that Ms. Perkins has knowledge of any sort of vandalization.
Any response?
No response. I'll just skip that question.
All right, I will sustain the objection. Feel free to move on or lay more foundation if you'd like.
Okay. All right, Ms. Perkins, let's talk about March 5th. March 5th was the day that Avery lost her phone.
Yeah, it was on Thursday.
Avery uses her phone a lot.
Yeah, I was usually never out of reach, but that night she was so mad at Alex Fuentes that she left her phone on the table, I'm pretty sure.
Avery uses her phone so much you call it her third kidney.
Yes, it was like her third kidney, actually.
You and Avery went to the Fry Shack together on March 5th?
Yes, which wasn't the best for my diet, but like, oh well, we're always at the Fry Shack.
After leaving the Fry Shack, you and Avery spent time at the mall?
Oh yeah, we did spend time at the mall. I love the mall, honestly. I love going shopping and everything.
Avery didn't use her phone at all after you left the Fry Shack?
No, she was super mad at Alex Fuentes.
Let's discuss March 6th, 2020. The morning of March 6th, Avery picked you up for school?
Yeah, but we didn't go to school that morning.
Avery had not answered your text messages that morning?
Yeah, it was really weird. She didn't answer my messages, and I brought it up to her in the car. I was like, yo, Aves, like, why didn't you answer my messages? It was weird.
So that's a yes, just to clarify.
Yes, she did not answer my messages.
You texted Avery that morning, but since you weren't sure, excuse me, let me say that again. You texted Avery that morning, but since they didn't answer your texts, you weren't sure Avery was taking you to school.
Yeah, but she came and we had our first period off, which was usually when we would go to school together.
And Avery noticed her phone was missing when you brought it up.
Yeah, we realized together.
You think Avery may have left her phone at the fry shack?
I think so.
You did not consider using the Find My iPhone program to find Avery's phone?
Yeah, I have an Android, so I can't really use that.
Can anyone testify to your whereabouts on the day of March 6th?
Yes, Avery. Me and Avery were together.
Finally, I would like to clarify some facts from your witness statement. You talked about Mr. Brackman's murder with Avery,
Yes.
and you knew your stories matched when you gave your statement.
Yeah, we were together the whole day.
You stated that you knew your stories matched.
I mean, we were together.
Right, but you stated your stories matched.
Oh, yeah.
No further questions, Your Honor.
All right. Any redirect examination?
No, Your Honor, not at this time.
Then this witness may be excused. Defense, call your next witness when you are ready.
The defense calls Professor Blake Van Owen to the stand. And I'm sorry, Your Honor, it may take a brief moment as we do have to sanitize the witness station.
Take your time. Say I appreciate that you're sanitizing the station.
Your Honor, I'm not sure if it's just my... Oh, never mind. Okay.
I think it just takes a second, but I can see your witness now.
All right. Thank you, Your Honor. Please state your name and spell the last for the record.
Blake Van Owen, Van-Owen.
And Professor, why are you here today?
Really here to show where the police first dropped the ball.
What do you do for work?
I'm a private investigator and I teach a course. I'm a professor.
Can you tell us a little bit about your experience in your work?
Yeah, I joined I started out as a police officer, but ended that left that force after an incident and became what some people call a mall cop, sadly. But then I was also an SRO.
Okay. Do you specialize in any smaller fields?
Yeah, totally. Fields that are actually perfect for this case. I would say cell tower analysis and crime scene reconstruction, or CSR.
Can you tell us about your experience or training in those fields?
Yeah, totally. I got my, excuse me. I got my experience being for CSR through multiple professional conferences, the same as Cusack even. And I have testified at least 5 other times as an expert witness in cell tower analysis.
And can you talk to me about this course that you teach? What does that entail?
Oh, yeah. I earned my master's degree through Ashford's University, and that's opened doors for like 5 years now. I teach a course on police practices and social justice. It's been great.
Your Honor, I now ask the court to accept Professor Blake Van Owen as an expert in crime scene reconstruction, cell tower analysis, general police investigation tactics, and police practices.
All right, can you tell me all those again real fast?
Yeah, of course. Cell tower analysis, crime scene reconstruction, police practices, and general police investigation tactics.
Right. Any objection or voir dire to any of those areas of expertise?
No, Your Honor.
All right. He shall be admitted in those, or admitted as an expert in those 4 areas. Thank you.
Thank you, Your Honor. Professor, did you conduct an investigation on this case?
Of course.
And did you find anything wrong with the prosecution's investigation of this case?
Yeah, wasn't that hard. I would say I found 5 major flaws.
And what are those?
Physical evidence, missing photos, or sorry, excuse me, physical evidence, missing photos, the texts from Cifuentes, Marquardt Cell Tower, and Blair Rollins, all 5.
Can you walk me through those one by one, starting with the physical evidence?
Yeah, that's really talking about Cusack. His main foundation is the scuff marks by the back door where the intruder entered, but we don't know how old those are, what caused them, or who even caused them. And on top of that, the knife, the murder weapon, didn't match any of the sets or brands that the victim owned.
Okay, and while we're on Cusack's theory, can you talk to me a little bit about their bear hug theory?
Yeah, the struggle.
Yes.
Totally. So I'm going to do a little visual to help the jury understand. Cusack's idea was that the victim and the intruder got into these bear hug motion and then the intruder got a knife that I believe they brought in over 2 shoulders.
2 shoulders, I'm sorry.
2 shoulders and got that whole 7-inch blade into the back.
Okay, and that brings us to our second flaw. What was that?
Yeah, the second flaw was the missing photos. The police force, unfortunately, had corrupted photos of blood splatter and blood drop evidence in a murder case.
Were you able to ever look at these?
No, sadly, and neither will a jury today in a murder case. Sorry.
Okay, and the third flaw, why were the texts from Alex a flaw in this investigation?
The police force could have easily have gotten Alexis Fuentes' phone at a later date. They could have easily have rescheduled or done something so it was more, solid instead of just screenshots from a high school student.
Okay, and what about this fourth flaw, Markowitz's overall investigation?
Totally. Markowitz's cell towers. I'll say this at the very start. Cell towers are not a pinpoint accurate system like GPS. It's just a broad area. And I did the math and it's about 38 square miles of range of just the 3 towers we use today. And on top of that, it's Avery Becker's phone, not Avery.
And I'm sorry, what makes you so sure Avery didn't have her phone?
Oh, Avery and Taylor both verified that they spent the entire day looking for the phone.
Okay, and that brings us to the last flaw that you found, Blair.
Yeah, Blair Rollins was another suspect by the prosecution or the police force. I did my own partial investigation into Blair, trying to see what I can uncover. And although I was unfortunately unable to locate him, I did come up with the fact that 1, he was absent the day of the murder from school, and 2, and he went to CHS, as we heard earlier. But 2, he matches the same height and build of Avery.
And what did you make of the police investigation on Blair?
There really wasn't one. He was stated as a unlocated party.
Okay, is there anything else about Blair we should know that's relevant to this case?
Briefly, as you heard earlier, Blair's father went to prison, and I just want to touch on that one more time. Blair's father, Jonathan Rollins, was represented by the victim in this case today, and unfortunately, Blair's father, Jonathan Rollins, went to prison for his entire life, and that can really change and hurt. I was a high school student, and Blair was there and heard his father yell out for revenge against Mackenzie Brackman.
Okay, thank you, Your Honor. I have no further questions at this time.
Cross-examination?
Yes, Your Honor. Sorry, technical difficulties at the moment.
You're fine. Let me know if we need to stop time.
Let's begin with your analysis regarding the murder weapon. You believe that the suspect could have brought it onto the scene themselves?
I feel it's very more likely because the knife brands don't match.
So you do not believe that the victim could have pulled a knife from the knife drawer?
Like I said, the knife brands don't match, so I feel like it's very more likely that the intruder could have brought it in from the outside.
So you believe that someone couldn't buy a knife from a different brand by themselves?
No, that's not what I'm saying.
You believe that you could also have obtained the tower records for the day prior to the murder in order to confirm that Becker and Perkins had been at the same locations a day earlier, but you didn't
In
do so.
hindsight, oh, excuse me, I'm sorry. In hindsight, I could have, but it's not. I'm not a police officer anymore. I'm not on the prosecution side.
So you didn't do so.
In hindsight, I could have, but I have not.
You also believe that the victim turning off his ring notifications would make him unaware of a break-in?
Yeah.
Objection, lack of foundation.
Ms. King, your response?
This was said in the witness's affidavit that he believes that due to turning off his ring notifications, he would be unaware of someone breaking into his home.
Your Honor,
Yeah,
if I
your
may
response.
respond. This witness has not testified here in court that they reviewed any such ring videos today.
So the fact that it's in the affidavit is a little different than the lack of foundation. So I'm going to sustain the objection at this time. Ms. King, if you could just lay a little more foundation about this ring video and this witness's knowledge.
Did you previously review the ring camera footage?
I reviewed all of the evidence I was given to, besides the blood splatter, of course. So yes, sorry.
Sorry. So you believe
No,
that the victim turning off his notifications would make him unaware of a break-in?
I believe that it's very, even if they didn't turn off the notifications, the amount of notifications that can come on a phone, especially for a lawyer, he could have easily missed it.
So the sound of the intruder trying to open the front door wouldn't have alerted the victim?
No.
The sound of the intruder opening the back gate?
It wasn't loud.
The sound of the intruder opening the back door?
Wasn't loud.
Your Honor, permission for the witness to view Exhibit 6? Let the record reflect that I'm showing the witness what has previously been marked as Exhibit 6. Do you recognize Exhibit 6?
I'm sorry, I do not see Exhibit 6 up on my screen. Are you screen sharing? Oh, okay, I see it now.
Okay. Do you recognize
Yes.
Exhibit 6? Okay.
Yes, I do.
What is Exhibit 6?
Looks like when the police brought in the murder weapon.
How do you know?
I reviewed all the evidence in this case.
Is Exhibit 6 a complete and accurate copy of this document?
Yes.
Your Honor, I move to admit Exhibit 6.
Objection?
No objection, Your Honor.
Exhibit 6 will be admitted into evidence. We shall constructively assume the jury can now see it.
Your Honor, permission for the witness to view Exhibit 21.
Yes.
Let the record reflect that I'm showing the witness what has previously been marked as Exhibit 21. Do you recognize Exhibit 21?
Yeah, it's like the knife from Psycho.
What is Exhibit 21?
It's the it looks like a picture from a report, just bigger,
How do you know?
because I omitted it, or didn't omit it, but I put it in.
Is Exhibit 21 a complete and accurate copy of this document?
Yeah. Yes.
Your Honor, I move to admit Exhibit 21.
Yes, Your Honor, lack of foundation.
Your response to lack of foundation, Ms. King.
The witness has made this picture themselves, so they would be able to talk about it themselves if they would wish to.
Any further response?
Yes, Your Honor, under Rule 403, this is simply wasting the jury's time as we already do have a picture of a knife.
Right. From looking at these, the knives are a little different. The pictures are different. So under 403, I'm going to overrule that objection. I'm also going to overrule on the lack of foundation grounds. I do believe the proper foundation has been laid. So at this time, Exhibit 21 will be admitted into evidence, and we shall constructively assume that the jury can see it at this point.
So you're saying this knife, Exhibit 21, is similar to the pictured murder weapon, Exhibit 6?
I haven't said that, no.
You used it as a reference showing how the murder suspect would use it. So I would expect that you would think it would be at least a little similar.
It's not what I've said.
Is the murder weapon's handle smooth?
I mean, it looks smooth, but I haven't held it.
Couldn't it be held either way comfortably?
I suppose it could, but if you're referring back to my report, that photo was used to show just like the movie scene Psycho and how it could have been used more easily.
Couldn't it be held either way comfortably then? If the handle's
I
smooth?
suppose it could, but for the way I was expecting, or the way my analysis went the other way, like Psycho, like it would have been easier like that.
Let the record reflect I've stopped sharing my screen. Don't you believe that the suspect brought the weapon onto the scene themselves?
As I've stated earlier, yeah.
How big was the murder weapon?
I think the blade's dimensions were about 7 inches, but I do not exactly remember, and I haven't talked about it.
Wouldn't a knife of that size be quite hard to conceal on camera?
I don't think so, especially since they were fully clothed and were very hard to see anything.
Did it seem that they were carrying a knife in the ring camera videos you looked over?
They could have easily been.
No further questions, Your Honor.
Any redirect examination?
Yes, Your Honor, a brief one. Professor, how did you come to this conclusion that the knife was held in this psycho-type fashion?
Oh, just from mainly my experience and careful review of this case, it made a lot more sense.
Okay, and how would the intruder have brought the knife with them as you reviewed the ring videos?
Oh, multiple ways. They could have had it up a sleeve. They could have had a holster for the knife inside their pants, back leg, in a shoe or sock. There's so many ways it could have been.
Thank you, Your Honor. No further questions.
Any recross in that area based on that redirect?
Sorry. No, Your Honor.
All right. All right, this witness may be excused. Defense, call your next witness when you are ready.
The defense calls Avery Becker to the stand, and we will need a minute to sanitize the area if that is okay.
Certainly not a problem.
And I can see if Miss Becker is on. Sorry for the wait.
Problem, no need to apologize. I see the black video footage. I believe that's going to take a second for it to register. See her now.
Our timer's ready.
Yes.
Please state your name, spelling your last for the record.
My name is Avery Becker. Becker spelled Becker.
Miss Becker, are you currently enrolled in high school?
No, I graduated Colorado High School last year.
Did you join any extracurriculars at Colorado High School?
Yeah, I was in mock trial, and it was everything to me.
Tell me a little bit about that.
Well, I joined mock trial my freshman year, did it all 4 years of high school. I felt that I was a natural at it, and it was just my passion. My best friend, Taylor Perkins, was on the team with me, so that was also wonderful.
Was there anybody else on the team that you know of?
Yeah, Alex Cifuentes.
Were you friends with Alex Cifuentes?
No, we weren't friends. We were just acquaintances and team members. Or so I thought until now.
Did you guys hang out outside of mock trial?
No, we didn't. I only ever saw Taylor at mock trial events. Alex.
We're going to talk a little bit about the mock trial team some more. Was there a coach on your team?
Yeah, Mackenzie Brackman, or Coach Brackman was our coach.
Tell me a little bit about your relationship with him.
Well, it wasn't always the greatest, to be honest. We had a lot of disagreements over my work ethic, but in the end, he got the team to a competitive place and was a good coach.
What were some of these disagreements about?
He told me often that I didn't put in enough work for mock trial, but I did. I knew what I was doing, and he just constantly undermined me.
Let's talk a little bit more about these disagreements. Were there any disagreements that stand out to you now?
Yeah, there was a practice after regional competition where I had won the Best Attorney Award and the Best Closing Argument Award. I was really proud, but Mr. Brackman told me that I didn't deserve them, so I was really angry. I took this marker that I was going to use to write on the whiteboard, and I walked outside because I didn't want to be insulted anymore, and wrote Worst Attorney Award on his car. I will never know why I decided to do that, but I did.
Did your feelings come into play to make you do this?
Well, I was embarrassed, sure, and I guess you could say that that I acted out of that.
How did you feel after you rode on Mr. Brackman's vehicle?
Well, at first I thought that would show him, you know. I thought the expo marker would just come right off and give him a good scare. But then when I realized it was permanent, I was mortified and couldn't believe I had made such a terrible mistake.
Did Mr. Brackman come after you after the argument?
Yeah, he came out to try and apologize to me, actually, which makes it all 100 times worse. But then he saw what I had done to his car, and he said, "That's it. I've had enough of your crap. You're off the team."
Heard an objection. What were the grounds?
Hearsay.
All right. Response to hearsay?
Under Rule 803, subsection 2, this is an excited utterance.
Ms. Wright, your response to excited utterance?
No response, Your Honor.
Given that there's no response, I will overrule the objection. You can continue.
Thank you, Your Honor. Would you like me to re-ask my question?
Yes, please.
What did Mr. Brackman do in response to finding out you rode on his car?
Well, he saw what I had done, and he told me that I was off the team and that he had enough of my crap, and that was it for me. That was the end of my mock trial career.
Where did you go after you were kicked off the team?
I went home. I just needed to get out of there, and I talked to my mom about it when I was back.
Did you tell her about the incident involving the car?
I didn't. I was so upset with myself. I couldn't even imagine how upset she would be. And it was so fresh. I just couldn't mention it that night.
After this incident happened, did you do anything to make up for what you had done, like apologizing?
Well, the very next morning, I went to Mr. Brackman's house first thing to apologize, but his secretary told me to leave. And so I went to mock trial practice later that day.
Yes, Your Honor, hearsay.
A response to hearsay? Ms. Thompson?
Your Honor, this is coming in for present sense impression because this is Miss Becker's present sense impression of how she perceived the situation and how Mr. Brackman was responding to her.
And I apologize. Could you repeat the statement for me one more time?
Would you like me to? Or?
Yes, if you could, Ms. Thompson, just tell me what the statement was.
Yes, Miss Becker previously stated that Mr. Brackman told her to leave.
Ms. Wright, your response?
Your Honor, I am objecting to the statement that the secretary mentioned that Mr. Brackman would not be speaking to Ms. Becker, and that does not fall under present sense and impression because it is the quote that the statement that the secretary gave.
Your Honor, may I respond?
Yes, your response to that statement.
Thank you. Although the secretary did say that, and I'm sorry I misspoke earlier, this again is present sense impression because this is how the witness perceived the situation in the moment, and because this was such a high intense situation of her wanting to apologize to Mr. Brackman, this is how this is included under present sense impression.
Ms. Wright, correct me if I'm wrong. The statement you're objecting to is that the secretary said that Ms. Brackman would not be speaking with Ms. Becker. Is that correct?
Correct,
All
Your
right,
Honor.
Ms. Tom. All right, I'm failing to see how that is a present sense impression. Present sense impression is something you basically describe as you're seeing it happen. I don't believe any proper foundation has been laid at this point for that to be a present sense impression. So at this time, I'm going to sustain that statement will be stricken and the jury will be instructed to disregard it. Ms. Thompson, if you can lay that foundation that it's present sense impression, I will allow you to re-elicit that statement.
Yes, Your Honor, thank you. Ms. Becker, did you go to Mr. Brackman's office?
I did, the morning of March 5th, yeah.
And were you instructed to leave?
I was. I didn't get to talk to him that day.
Did you do anything else to apologize to him?
Yeah, I went to mock trial practice actually that night in an attempt to apologize. I was just so eager to talk to him, and he told me to get out again, and so I didn't get to talk to him. I just continued to try and text and call him, but he never responded.
Ms. Becker, we're going to talk a little bit more about March 5th. Where were you the night of March 5th?
I went to the Fry Shack with Taylor because I was so upset not having been able to speak to my coach. Yeah.
And did anything happen at the Fry Shack?
We ran into the rest of the mock trial team, including Alex Cifuentes.
Did anything happen with Alex?
We disagreed. Alex was being rather condescending to me that night, or it seemed that she was. So Taylor and I didn't stay for long.
And do you remember grabbing your phone that night?
I don't remember grabbing it. I must have left it with Alex.
We're going to talk a little bit about March 6, 2020. Can you walk me through what happened in the morning of March 6th?
Yeah, I woke up and sometime that morning realized that my phone was gone. And so proceeded to go look for it with Taylor.
Were you with Taylor the whole entire day?
I was. We were searching for that phone all day.
Did you ever go to Brackman's house?
No, I don't even know where Brackman lived.
We're going to talk a little bit more about your relationship with Mr. Brackman. Did any of the arguments or disagreements you had caused you to want to hurt him?
No, absolutely not. I can have disagreements with people and not resort to violence.
Did you ever hurt Mr. Brackman?
No. All I wanted was to make amends for the car, and I never would have moved to hurt Mr. Brackman.
How do you feel after the loss of your coach?
I don't know, man. I feel sick every time I think about it. I can't sleep. I can't eat. There's so much I need to say to him, and I just know that I'll never be able to do that, and it tears me up every day.
And lastly, Ms. Becker, did you kill Mackenzie Brackman?
No, I would never, ever kill Mr. Brackman.
Thank you. No further questions.
All right, cross-examination?
Yes, Your Honor. Mr. Becker, let's start with your relationship with Mr. Mackenzie
Miss.
Brackman. Miss, my apologies. Mr.
That's
Brackman
fine.
would frequently tear you down,
Yeah, he was really tough on me.
claiming that you were lazy.
Yeah.
This upset you, correct?
Yeah, I mean, it definitely hurt when he said those things.
It upset you enough to damage property.
Yeah, well, I thought it was another one of my harmless pranks. It was just a mistake.
Let's talk about the night that you damaged Mr. Brackman's property. Mr. Brackman came in and immediately started telling you you didn't deserve the award you won, correct?
Yeah, well, pretty soon into practice, he started in on his critique, yeah.
He came in right before you were about to write on the whiteboard.
He was there, yeah. I think he was there the whole practice, but yeah.
So when you left, you still had the whiteboard marker in your hand.
That's correct.
And you vandalized Mr. Brackman's car by writing Worst Attorney Award in permanent marker.
I did. I just thought it would wipe off.
Was the marker you used a dry erase marker?
No, I later found out it was permanent.
If you had used a permanent marker on the whiteboard, you would have ruined the board.
Yeah. I don't know why it was there, but that's what was by the board, so
After that incident, he kicked you off the team.
he did.
Mr. Brackman ignored your attempts to apologize.
Yeah, he was pretty upset, understandably.
And this upset you?
Yeah, I just wanted to apologize.
Finally, let's talk about your phone. You last recall having your phone on March 5th at the Fry Shack?
Yep.
So throughout that entire evening, you did not notice that you did not have your phone on you.
No, Taylor and I went to the mall after the Fry Shack, and I wasn't thinking about it.
It took you
I was
until
pretty.
the next morning to realize that you did not have your phone with you.
That's right.
So you skipped school to go find it with Taylor Perkins.
Yeah, we didn't have much important material going
Did you
on,
use
so
any
we
resources
decided.
to find your phone?
We tried texting and calling it, that's it.
So you were looking for your phone using no tools except for your memory of where you had been the night before.
Yeah, we weren't very tech savvy. I guess we didn't think of anything else.
Did you ever find your phone?
No, it's gone.
And finally, you brought up on direct that you never hurt Mr. Brackman.
I didn't. I would
you
never
consider
do
vandalism
anything.
hurting Mr. Brackman?
Well, the fact that I didn't realize that marker was permanent, sorry, my screen. I didn't know that I was going to be causing any kind of harm to Mr. Brackman, so it was not intentional.
But you did write on his car.
Yes, with what I thought was expo marker.
No further questions, Your Honor.
Any redirect examination?
Yes, Your Honor. May I have a brief time check?
Of course.
You have 41 seconds.
Miss Becker, did you know that the marker was permanent when you were writing on the car?
No, as I've mentioned, I had it in my hand to write on the whiteboard, and so naturally I assumed it was a whiteboard marker.
Thank you. No further questions.
Cross based on that.
Briefly, Your Honor. Ms. Becker, you claim that you did not know that the marker was a whiteboard marker,
I didn't.
but you still wrote on Mr. Mackenzie Brackman's car.
Objection, Your Honor. Asked and answered.
Ms. Wright?
Your Honor, as this is a recross, it is re-asking questions that were brought up in the redirect.
Your Honor, may I respond?
You may.
The question that she just asked, I did not ask in my redirect. That was asked in co-counsel's previous cross, and it was answered by my client already, so it is considered asked and answered under Rule 403.
I was trying to remember if it was in the cross. I recall this question being asked in cross. Ms. Wright, any further response before I rule?
No, Your Honor.
All right, so that objection will be sustained. I believe you were on mute. What was that? You put yourself back on mute when you answered that. You are unmuted right now.
Oh, you're right. Sorry.
You're
No further
fine.
recross.
All right, this witness may be excused. Defense, do you have any further witnesses?
No, Your Honor. The defense rests.
We're going to take just a couple seconds here for our scoring panelists to get caught up if they need to. All right, before we begin closing arguments, I just want to run through what exhibits were admitted so we're all on the same page. I've got 1, 2, 3, 4, 6, 8, 9, 14, 15, 18, and 21 all admitted that you are free to use in your closing arguments as you see fit or not. Prosecution or people, are you ready for your closing argument?
Yes, Your Honor.
You may begin when you're ready.
Our actions prove the truth of our words. Today, you've seen arguments from two sides of the courtroom, yet only one has presented you with the real truth. We acknowledge that the prosecution carries the burden of proof, which is beyond a reasonable doubt, and the prosecution has met that burden. For this trial, there are two charges against the defendant, the first charge being the action of first-degree murder. The elements of this crime including committing or even attempting second-degree burglary, and then someone dying in their company. For the crime of second-degree burglary, this includes knowingly breaking into a dwelling, which in this case is the victim, Mr. Brackman's home, with the intent to commit criminal mischief. Criminal mischief means that the defendant broke in with the intent to damage Mr. Brackman's property. The defendant's intent is proven by Exhibit 14, which is screenshots between Cifuentes and the defendant. Cifuentes was a friend of Avery's who came to testify. These screenshots clearly entail the defendant stating, "I'm gonna wait until he's at work, then break in and trash it. Wait till he sees what I do to his house." These screenshots being testified as authentic by Cifuentes, there is no doubt that there is intent within the defendant's words. This intent being the action of attempted burglary. This truly shows that our actions prove the truth of our words. The defendant planned to break into her coach's house to seek revenge, and it was the defendant who committed this crime that very afternoon. Becker had a motive. The relationship between the two had been strained. She was kicked off the mock trial team right before her biggest tournament of her senior year. Today in court, she testified that when she wrote on her coach's car, she thought, "That'll show him," which is verbatim to the text messages that show intent discussed prior. Avery had been on the mock trial team for the past 4 years and was extremely passionate about the club. This would lead Becker to seek revenge by trashing his house while he was away. As the victim heard the intruder attempting to enter the dwelling, he grabbed a knife from within his kitchen, whether it be the knife block with the convenient space left within, which later became the murder weapon. This then led to a physical struggle between Avery Becker and Mr. Brackman, as shown as Exhibit 9, a broken plate, and Exhibit 18, scuff marks on the floor. Detective Markowitz also testifies to cell tower records showing that the defendant was at the scene of the murder at the time. Perkins' bias also needs to be addressed. She even testified that she was about to punch Alex Cifuentes in the face, who is on the prosecution side. She also testifies today to saying, "I love murder, honestly." This would be suspicious for someone whose best friend is being tried for murder this very day. The defense believes that Alex and Blair were friends and came together to go against Avery. However, Taylor Perkins says today that they were complete opposites of each other. Professor Van Owen, who is critical of the prosecution's investigation techniques, testifies today that he didn't look into more evidence because he's not on the prosecution's side. When asked if a knife that is almost a foot long from end to end would be easily seen on camera, a suggestion was that the suspect could hide it in his soccer shoe. However, doing something like this would be extremely uncomfortable and could possibly cut them or make them walk with a sort of limp. Also, Becker claims she conveniently lost her phone before the crime occurred. This would be suspicious for someone whose phone is their third kidney. Her losing her phone would have it be impossible for authorities to verify what was on her phone around the time of the murder. I would like to remind the jury that this is a case of murder in the first degree, something that must be dealt with in the correct manner and swiftly. Someone's life has been lost due to the actions of the defendant, and the appropriate actions must be taken in order to find justice. I ask the jury to find a defendant guilty of murder in the first degree, as well as second-degree burglary. The defendant's actions truly prove the truth of her words. Thank you, Your Honor.
Your Honor, I apologize. I was not able to hear you there. Were you just asking for defense? Closing argument? I apologize. I'm still unable to hear you. I believe you may be on mute, Your Honor.
Because I was on mute. I'm sorry about that. I was just
No
asking if
worries.
the prosecution is reserving remaining time for rebuttal.
Yes, Your Honor.
All right. And Ms. Miller, closing argument for the defense.
And Your Honor, do you mind if I wait just a moment for my camera to load?
I would prefer if you do, actually. Be nice to see you while you do it.
Thank you. Oh, there we go. Okay.
All right, then begin when you're ready.
Okay, and before I begin, I would just like to confirm that timers are ready.
Yes.
The less I see, the more I know. Ladies and gentlemen of the jury, today we have heard the case of the people of the state of Colorado versus Miss Avery Becker, and you have been called to determine whether Miss Becker, the defendant in this case, is in fact responsible for all of the crimes in which she has been charged here today. We saw 6 witnesses take the stand today, the first 3 on behalf of the prosecution. We first saw Detective Jordan Markowitz and Kyle Kuzak take the stand. Detective Markowitz, along with Kyle Kuzak, laid out stories and investigations backed solely by falsified and partial evidence, and more so explained to us how the prosecution lost evidence in this case, meaning that there are key photos of not only blood splatter, but blood drops that you, nor I, nor the defendant in this case will have the opportunity to see here today. The less evidence I see presented by the prosecution, the more I know that they have failed to present you with their entire case here today. We also saw Alex Cifuentes take the stand on behalf of the prosecution today. Alex Cifuentes, who made unsupported claims in a desperate attempt to authenticate a text conversation that supposedly ensued between him and my client, Miss Becker. But we were never able to truly authenticate this text conversation, as no effort was made by either of the prosecution's expert witnesses to gain access to Ms. Cifuentes' phone itself. We also saw Alex Cifuentes make claims of a supposed best friend relationship with my client, Ms. Becker, here today. But the less I see of Alex Cifuentes testifying on behalf of their supposed best friend here today, the more questions I have not only about their relationship, but about the story that Alex Cifuentes has presented us with here today. We also saw the 3 witnesses take the stand on behalf of the defense today. We saw Avery Becker, who I'll remind you has no duty to testify before you here today. She is only here to clear her name. Ms. Becker, along with Ms. Taylor Perkins, provided to us clear and simple testimonies, and the less discrepancies I see between these testimonies, the more I know about the true validity of their alibis from March 6, 2020. We also saw Professor Blake Van Owen take the stand on behalf of the defense today. Professor Van Owen, who laid out his thorough and well done investigation into this case, and more so explained to us how there were suspects in this case that the prosecution failed to fully investigate, including Blair Rollins. The less suspects I see presented by the prosecution, the more I know of the lazy job done not only in their investigations, but in the prosecution's job of seeking justice for Mr. Brackman here today. Ladies and gentlemen, I now ask you to think of yourself as you were in high school, and think of someone that you may have bickered with at this age. Whether it was your mom, your dad, your sister, your brother, your coach. But think of how, despite any bickering or arguments that ensued between the two of you, you ended up here. You ended up all right. But what if you hadn't? What if something terrible had happened to that person that you just imagined and you had been blamed for it? What if you had been subpoenaed to court to plead to complete strangers that you were in fact not the one responsible? You would want them to see you as the bright, young student that you were. And you would want them to hear you, especially as they made their final decision in your case. Ladies and gentlemen, I will now direct your attention to jury instructions 7, 8, and 9, all of which outline all of the elements that the prosecution must prove in order to meet their burden of proof today. I'll remind you that if the prosecution fails to prove even one of these elements beyond a reasonable doubt, that Ms. Becker must be found not guilty on all accounts. As we can see outlined in jury instructions 7, 8, and 9, the prosecution has not only failed to prove that the crimes charged even occurred within the state of Colorado, but that the defendant was, in fact, beyond a reasonable doubt, the one responsible for the crimes charged. The less I see of the prosecution's ability to meet this burden of proof today, the more I know that each and one of these elements show that they have not met that burden. The less I see of the prosecution's ability to meet this burden of proof today, the more I know that Avery Becker must be found not guilty on all accounts. Ladies and gentlemen, the prosecution reminds us that actions prove words, and the less actions taken by the prosecution to prove each and every one of their elements prove the words, Avery Becker is not guilty on any account. Thank you.
All right. Ms. King, any rebuttal?
Yes, Your Honor. Throughout this case, it has been proven that actions truly prove the truth of our words. The defense claims that the less I see, the more I know. However, it's evident that the more I see, the more I know. The more evidence shown throughout the trial, the more convincing the prosecution's case is. Text messages clearly stating intent have been shown throughout this case. The less evidence the defense chooses to see, the more they think they know. Thank you, Your Honor.
All right, that will conclude the trial. Congratulations. What we're going to do now is I'm going to let the scoring panelists finish up their scores, give them a minute. If team members wouldn't mind turning on your cameras, just so I'm not talking to myself, feels a little weird. What I'm going to do here briefly is I'm just going to introduce myself and share a quick little fun fact with you. And then as soon as I get confirmation that our scores are good and submitted, we'll discuss how feedback's going to go. So my name's Kelsey Madden. As you can see, if you've not yet met my dad, Judge Madden, I'm sure you will at some point. I am a deputy district attorney in Denver, so obviously I love trials. I personally competed in mock trial for about 11 years. I've been to the state competition 4 times. I did a national competition in law school. I've coached multiple teams. Basically, I just love it, and I'm always happy to come judge. It makes me very happy. The thing I wanted to share with you guys, though, is those pictures of the dead body. That would be pictures of my dad, and that would be the doorway of the house that I grew up in. And I gotta tell you, seeing them every time, it's so weird to see, like your own dad laying in the foyer of your house. And it just makes me kind of laugh because it's so ridiculous. I recognize those knives, all sorts of things I grew up with that are still around. So if it looked like I was laughing or having some struggle, that's the reason why. The last thing is, if you competed in mock trial last year and you remember Pepper Marie Clementine, that's actually my dog. She is right here. And she's been sitting here with me the whole time. So obviously I'm solidly related to this mock trial program. Other than that, in terms of feedback, do we have all our scores in?
Yes, Your Honor, scores are confirmed.
All right. So I know this is the 4th round. You guys have had a very busy weekend, a few days here. So all I want to say is everyone did great. You're obviously very well prepared, and certainly at this 4th round, you've got things pretty much under control. The only thing I want to say, well, first of all, I should say, attorneys, thank you for your preparation. You've got a really good grasp of the rules of evidence. That's greatly appreciated. Witnesses, I love the characters. Fantastic job keeping the character going through cross-examination. The only thing I want to say to you is I understand virtual court, virtual trial is quite the thing. Don't be afraid to move back a little farther from your camera, use some more hand gestures. Obviously, I can't see you guys walking around. I can't see witnesses putting their character into walking up to the stand or looking around and all these things. So adding a little more tone variation, volume variation, a little more emotion, sitting back where I can see some more hand gestures are all things that can help. Just changing your posture in your chair even can be helpful. But all that's just things to help you. And if you do want to be an attorney and we ever get back into this virtual world. Other than that, I'm going to pass it off on to our panelists. But I am going to type my email into the chat here. I write a lot of notes throughout the trial. I have lots of notes for everyone. If you have questions and want specific feedback, email me. If you don't, I won't be offended if you don't email me. It's just if you want anything. But I'm just going to go ahead and pass it off to our panelists if anyone would like to start.
I'll just keep it short. I enjoyed watching this. Last 3 days were my first foray into participating in, watching, helping to judge mock trial, and I thought you all did a good job. The one standout thing for me, Miss King, in your closing, I thought that the first part of it could have used a little bit more intonation and voice. But what really stuck out to me was your rebuttal closing argument and just being able to think on your feet in a very short period of time and address effectively, what the other side said in their closing, kind of thinking on your feet. I thought that was very, very impressive.
Can go next. For context, I'm actually a 3rd-year law student, and so if at any point after this session I will leave, of course I'll leave my email in the chat box. So if you have any questions about undergrad or law school in these weird times, feel free to reach out to me. As far as general critiques go, I echo everything that Kelsey said. It's really hard doing trials on Zoom, and you'll find that if you do work with clients, it's harder to have conversations with clients as well on Zoom. And so to be more engaging to the camera, although it feels really awkward, is really, really important in this day and age. The gesticulations, the kind of moving around is something that the jury, clients, normal people that aren't part of the legal field will feel more, will react to more, and will relate to more. So that's a general critique that I have. But your hard work, your focus, your preparation is very, very evident in your performance. It was a pleasure to be a part of this. For those of you who played attorneys, your grasp of the FRE was very, very impressive. I took it last year, and honestly, I forgot most of the stuff that you were bringing up. And so I was very impressed. For those of you who played witnesses, your performance was very entertaining. I had a blast. I did take a lot of notes for all of you. And so if you want to discuss specific performances, please do reach out to me. But thank you all so much for a great time.
I just want to say, you're all very well prepared, and you all put on the case the best the case allowed you to, and I didn't see very much that I would critique, as you all did very well. So that's all.
Great. So I have been given confirmation that we are good. Scores are in. Everything's good. So everyone is free to go. I know there's a lot of drama and excitement about to happen. So I'll let you all go get ready for that. Thank you all for everything. Great job again.
Thank you.
Thank you so much.
Thank you.
Thank you.
For your time.